Welcome to the deep dive. Okay, so today we have a really important mission, I think. We're diving into, well, it's a pretty dense stack of legal code. We're looking at Chapter 21 of the Texas Penal Code. This is the chapter covering sexual offenses. Our goal here isn't just to skim the surface. We want to really dig in and pull out the clarity, the understanding you need to grasp how the law actually defines and deals with these really serious acts. And hey, before we really get started, if you find this kind of detailed legal breakdown valuable and you want the shortcut to being genuinely informed, please hit that subscribe button. It really helps us keep these deep dives going, helps the channel grow. It's your support that makes this possible. And definitely check out our website too. All the resources, the citations, everything we're using today, it's all there for you.
Absolutely. And, understanding this kind of language, statutory language, it's crucial. It's not like everyday conversation, right? Legal code is built for maximum precision. Every word matters. As we go through Chapter 21, you might actually be surprised at just how specific these definitions have to be. We'll look at how the law defines basic acts, how it handles older public order stuff, and maybe the most interesting part, how it's really trying to keep up with digital tech.
Yeah, the digital side is fascinating.
Oh, definitely. A misplaced comma, forgetting one little word about someone's mental state, that can change the entire outcome of a case.
Okay, so let's approach this systematically. We'll start with the basics, the foundation, like what do terms like sexual contact or intercourse legally mean, according to this chapter. Then we'll get into the trickier stuff, like continuous abuse laws. After that, we'll pivot to offenses about public behavior, educator boundaries, and finally, spend some real time on the modern challenges, visual media, deep fakes, electronic stuff.
Right. And the first thing that often strikes people is that these definitions, even for what seem like simple physical acts, they're not intuitive at all. They're the product of, decades of laws being written and courts interpreting them, all designed to stamp out any ambiguity later on in a courtroom. It's really like legal engineering, sometimes incredibly complex but necessary.
Okay, let's dive into that foundation then. Section 21.01, these are the building blocks, right? Before the state can even think about charging someone, the alleged act has to fit neatly into one of these very specific boxes.
Precisely. Let's start with deviate sexual intercourse, often shortened to DSI. The term itself sounds, maybe a bit old-fashioned, but it's deliberately broad. It's meant to cover sexual acts that aren't traditional penile vaginal intercourse. And it has two distinct components, equally serious under the law.
Okay, walk us through the first part. That one seems focused on specific body parts.
Right. Part A defines it as any contact between any part of the genitals of one person and the mouth or anus of another person. So basically, that covers oral sex or anal sex. And defining it this way is crucial because, as we'll see later, it means these acts, if non-consensual, are treated just as seriously as non-consensual traditional intercourse.
Okay, that makes sense. And Part B, this is the one that sometimes catches people off guard, isn't it? Because it goes beyond just body-to-body contact.
It absolutely does. Part B defines DSI as the penetration of the genitals or the anus of another person with an object. The legal thinking here is about parity. It ensures that if someone penetrates another person without consent using an object, it's charged under the same serious category, DSI, as non-consensual oral or anal sex. It's not just, say, an aggravated assault charge. It's recognized as a severe sexual offense against the person's bodily integrity, no matter what was used for penetration.
Got it. Okay, moving on to sexual contact. The definition sounds simple at first, touching the anus, breast, or genitals of another person. But like you said, the mental state is everything here, right? To separate criminal acts from, say, accidental bumping or a doctor's exam.
Exactly. That's the absolute core of sexual contact. The touching itself isn't enough. The law explicitly adds that the touching must be done, quote, with intent to arouse or gratify the sexual desire of any person. That phrase, that specific intent, is the legal firewall. A prosecutor has to prove, beyond a reasonable doubt, that the person's main goal, their mental state at the time, was sexual arousal or gratification, their own or the other person's. Doesn't matter whose. That's what separates, a medical procedure or bumping someone on a crowded bus from an intentional crime.
Yeah, we should probably flag this now. You mentioned it earlier. This is the base definition. We'll see later that the lawmakers deliberately changed this, made it broader when the victim is a child or a student. They recognized those situations needed different rules.
That's right. That flexibility in the law is interesting. Now, sexual intercourse. This one is actually, maybe surprisingly, the most narrowly defined term in this section. It's defined very restrictively as any penetration of the female sex organ by the male sex organ, period. It sticks purely to that traditional biological definition.
Right. And, okay, while we're on definitions, we have to touch on some history here. Section 21.06 is still technically in the source code, the one about homosexual conduct.
Yeah.
We need to be clear about its status.
Yes, absolutely critical point. Listeners need to understand, while you can still find the text of Section 21.06, which criminalized deviate sexual intercourse between individuals of the same sex, it is completely, utterly unenforceable. Back in 2003, the U.S. Supreme Court case, Lawrence v. Texas, struck it down. The court ruled it violated the Due Process Clause of the Constitution, basically saying the government has no business interfering with private, consensual sexual conduct between adults.
That was a huge landmark case. So why does the text still physically exist in the penal code if it's unconstitutional? This is confusing.
It often happens with statutes that get overturned. Sometimes the legislature just doesn't formally repeal the text right away. It stays there, maybe marked as unconstitutional in annotations, kind of like a historical marker. It shows where the law used to be, but it has zero legal force today. Think of it like a legal fossil.
Okay, good clarification.
Yeah.
So we have the basic definitions down. Now let's move into how these definitions are applied over time in patterns. This feels like a big jump in legal complexity. Section 21.02, continuous sexual abuse.
It is a big jump. Section 21.02, continuous sexual abuse of young child or disabled individual, is, frankly, one of the most serious charges you can face in Texas. Its whole structure is designed to tackle the immense difficulty of prosecuting abuse that happens over a long period.
So what makes it continuous in the eyes of the law? What are the mechanics?
Okay, the core elements are: the prosecution needs to prove 2 or more acts of sexual abuse. These acts must have occurred over a period lasting 30 days or more. That duration is key. Also, the person accused, the actor, must be 17 years old or older, and the victim must be either a child younger than 14, and it doesn't matter if the actor knew their exact age, or a disabled individual. The law recognizes that disabled individuals, regardless of their chronological age, can have the same level of vulnerability as a young child.
And sexual abuse for this specific section isn't just one thing, right? The law points to a whole list of other serious crimes. Why do it that way?
Right, that list is in subsection C. It includes things like sexual assault, aggravated sexual assault, certain types of indecency with a child, aggravated kidnapping if the intent was sexual abuse, even certain burglaries if the intent was to commit a sexual felony. Pulling all these underlying felonies together under the umbrella of act of sexual abuse does 2 main things. First, it drastically increases the potential penalty. Second, and maybe more importantly from a prosecution standpoint, it helps overcome the huge evidence problems you often see in long-term abuse cases.
How does it help with the evidence? What's the challenge it solves?
Think about it. When abuse happens repeatedly over months or even years, victims, especially young children, often can't remember the exact date, the specific time, or the precise details of every single instance. It's just not how memory works, especially with trauma. So trying to prove one specific incident beyond a reasonable doubt, with all the required details, can become almost impossible if the victim's testimony is understandably vague on those specifics. This statute lets the prosecution focus on proving the pattern of abuse, the continuous nature, rather than needing to nail down every exact detail of 2 separate, distinct incidents.
And that connects directly to that really unusual rule about the jury, right? Section 21.02 deal about unanimity.
Yes. This is probably one of the most legally interesting parts of the statute, and it's been challenged constitutionally, though upheld. Normally, for a criminal conviction, the jury has to agree unanimously on all the essential elements of the crime, exactly what happened, when, how. But for this specific charge, the law explicitly tells the jury they do not need to agree on which specific acts of sexual abuse occurred or the exact dates.
Wow. So they all have to agree the pattern definitely happened, but they don't need to agree on, like, which specific Tuesdays it happened.
That's a good way to put it. The only thing they must agree on unanimously is that at least 2 qualifying acts of sexual abuse occurred sometime during that 30-day or longer period. The idea behind this, the legislative intent, was purely practical. It's to make it possible to hold abusers accountable for the systemic nature of the harm, even when the specific details of any single event are lost to time or trauma.
Okay. And given how serious this is, it's a first-degree felony, minimum 25 years, could be life. Is there any way out? You mentioned a defense, but it sounded pretty narrow.
Extremely narrow. It's an affirmative defense, meaning the defendant has a burden to prove it, and it only applies if the victim was a child, not a disabled adult. The actor has to prove 3 things, all of them. 1, they were not more than 5 years older than the child victim. 2, they did not use any force, duress, or threats. And 3, they weren't already required to register as a lifetime sex offender for some prior conviction. It's really designed for very specific, arguably less predatory situations involving people very close in age, and it's very hard to meet those conditions in most typical continuous abuse scenarios.
Makes sense.
Oh.
Okay, let's touch briefly on the next section, 21.03. This also covers continuous sexual abuse, but the focus shifts slightly.
Right. Section 21.03 is very similar structurally to 21.02. It still targets that pattern, 2 or more acts over 30 days or more. The actor still has to be 17 or older. The key difference is the victims. Here, the 2 or more acts of sexual abuse must be committed against 2 or more victims.
So this is aimed at ensuring that someone who victimizes multiple people over time also faces this really severe charge.
Exactly. It closes a potential loophole and ensures that pattern abusers targeting multiple individuals are covered. The definition of what counts as an act of sexual abuse is exactly the same list of serious underlying felonies we talked about for 21.02. And importantly, that same jury unanimity rule applies. The jury has to agree unanimously that the 30-day pattern happened involving 2 or more victims, but they don't need to agree on the specific acts against specific victims on specific dates.
And the affirmative defense here, similar conditions.
Very similar. If the victims were under 17, the defense is available if the actor wasn't more than 5 years older than the youngest victim involved. Again, only if there was no force or duress and no prior lifetime registration requirement. Both 21.02 and 21.03 are first-degree felonies, carrying that same potential for a life sentence.
Okay, shifting gears now. We're moving away from those severe pattern offenses and into laws more focused on public order, location, and decency. These seem to hinge a lot on where something happens and what the actor was thinking about who might see them.
That's a good summary. Let's start with public lewdness, section 21.07. A person commits this offense if they knowingly engage in one of 3 acts, sexual intercourse, deviate sexual intercourse, or sexual contact, using those strict definitions from 21.01, but the key is the location or the mental state about observers.
What are the location or mental state conditions?
2 possibilities. 1 is straightforward. They commit the act in a public place. Simple enough. The second condition covers acts done not in a public place, maybe somewhere semi-private. Here, the mental state required is recklessness. They have to be reckless about whether someone else is present who will likely be offended or alarmed by the act.
Reckless. That's interesting. So it's not about intending to offend someone, but more about not caring if you do, failing to consider the possibility.
Precisely. It imposes a kind of duty to think about the potential impact on others. You might be in your car or behind some bushes thinking you're alone. But if a reasonable person would realize someone could walk by and be offended or alarmed, and you engage in the act anyway, that recklessness satisfies the statute. It usually starts as a Class A misdemeanor. But notice the kicker. It jumps way up to a third-degree felony if the person has previously been civilly committed as a sexually violent predator.
Okay, let's pause on that term, civilly committed as a sexually violent predator. What exactly does that mean for our listeners? It sounds different from just a criminal sentence.
It is very different. Civil commitment happens after someone has finished serving their criminal prison sentence for a sex offense. If the state believes, based on expert evaluation, that the person has a behavioral abnormality, making them likely to commit future predatory acts of sexual violence, a court can order them confined to a secure treatment facility. It's technically civil, not criminal confinement, aimed at treatment and public safety. So when the law says an offense becomes much more serious if the actor has this status, it's reflecting a judgment that this person poses a significantly higher risk, warranting a harsher penalty for any new offense, even a misdemeanor like public lewdness.
Understood. Okay, next is indecent exposure, section 21.08. How is this different from public lewdness? Lewdness covered acts. This sounds like just showing.
Exactly. Indecent exposure is purely about the exposure itself. The actor has to expose their anus or any part of their genitals. Critically, they must do this with a specific intent to arouse or gratify sexual desire, their own or someone else's. That sexual intent is vital. And similar to the second part of lewdness, they also have to be reckless about whether someone else is present who will be offended or alarmed. What's really notable here is the penalty structure. It's clearly designed to crack down hard on repeat offenders.
Yeah, I see that. It climbs pretty quickly.
It does. A first offense is a Class B misdemeanor, but just one prior conviction for the same thing bumps it up to a Class A misdemeanor. If they have 2 or more prior convictions, it becomes a state jail felony.
A state jail felony. Remind us what that means compared to other felonies.
Right, so Texas has this category. State jail felonies carry potential punishment of 180 days to 2 years in a state jail facility, which is separate from the main prison system, plus a fine up to $10,000. It's less severe than, say, a third-degree felony served in prison, but it is still a felony conviction with all the consequences that follow: losing voting rights while serving the sentence, gun ownership rights, difficulties with jobs and housing. And again, like with public lewdness, if the person is a civilly committed sexually violent predator, indecent exposure automatically becomes a more serious third-degree felony.
Got it. Now, before we move off public order, there's bestiality, section 21.09. This one got a major update in 2017, didn't it? The level of detail is kind of striking. Why spell it out so meticulously?
Yeah, the 2017 changes were significant. They made the statute incredibly comprehensive. The legislative thinking seems to have been twofold. First, to clearly classify these acts as a severe form of animal cruelty, deserving of felony charges. Second, to cover basically any form of involvement, not just the direct physical act, but also facilitating it, promoting it, even just watching it. They wanted to leave no loopholes.
Okay, can you break down the main types of physical acts it covers? There seem to be quite a few.
Sure. The statute lists several, but the core physical acts are: 1. Direct contact between the person's mouth, anus, or genitals and the animal's mouth, anus, or genitals. 2. Fondling or touching the animal's anus or genitals, whether directly or through clothing. 3. Causing the animal to come into contact with the person's seminal fluid. And 4. Penetrating the animal's anus or genitals with any object or any part of the person's body.
And you mentioned it goes beyond just the person doing the act. It covers people who enable it too.
Absolutely. It's also an offense under this section to knowingly possess or sell an animal for the purpose of bestiality, or to organize or promote an event involving bestiality, or even just to participate as an observer. Offering your own animal for this purpose is also explicitly outlawed. It really targets the entire network, recognizing the harm isn't just the physical act, but also the exploitation and promotion surrounding it.
Is there an exception for, like, vets or farmers doing necessary procedures?
Yes, critically there is. The law specifically exempts generally accepted and otherwise lawful animal husbandry or veterinary practice. That's essential to avoid criminalizing legitimate animal care. The baseline penalty for bestiality is a state jail felony, but it gets elevated to a second-degree felony, a much more serious charge served in prison if the act was committed in the presence of a child under 18 or if it resulted in the serious bodily injury or death of the animal.
Okay, that covers the public order side. Now, let's focus back on vulnerability. Specifically, offenses involving children and those involving misuse of authority in schools, starting with indecency with a child, section 21.11.
This is a cornerstone statute for protecting minors. The key age here is a child younger than 17. And again, the law makes it clear. It doesn't matter if the actor knew the child's exact age or even the child's sex. Strict liability on the age element. The statute then lays out two main ways this offense can be committed, with different penalty levels.
What's the more serious version?
That would be subsection A1, which deals with sexual contact. If the person engages in sexual contact with the child or causes the child to engage in sexual contact with the actor or someone else, that's a second-degree felony.
And the other version involves exposure, similar to indecent exposure, but aimed at a child victim.
Exactly, that's A2. This happens if the actor exposes their own intimate parts, genitals, anus, pubic area, or female breast, or causes the child to expose their intimate parts. Critically, this exposure must be done with the intent to arouse or gratify sexual desire, the actor's or someone else's, and the actor must know the child is present. This exposure offense is a third-degree felony.
Okay, now here's where we revisit that definition of sexual contact. You flagged this earlier. The law specifically throws out the standard 21.01 definition when the victim is a child under 21.11. Why make that change here, and what does it mean practically? It's a deliberate choice by the legislature. They recognize that the standard definition, requiring touching of the intimate parts with intent to arouse, might be too narrow to protect children effectively. So for indecency with a child only, section 21.11c broadens sexual contact in two important ways. First, it includes touching of the child's anus, breast, or genitals, even if it happens through clothing. Second, and this is a big expansion, it also includes any touching of any part of the child's body with the actor's own anus, breast, or genitals, again, including through clothing. So touching through clothing counts. That seems like it could be harder to prove the necessary intent sometimes if there wasn't skin-to-skin contact.
Yeah.
How do prosecutors handle that?
It definitely presents evidentiary challenges, yes, but by lowering the threshold for the act itself, making touching through clothing sufficient, the law allows the prosecution to focus more intensely on proving the actor's intent through other means. The evidence might involve the context of the touching, repetition, statements made by the actor, grooming behaviors, things like that. The law essentially says the physical barrier of clothing doesn't negate the potential harm if the underlying intent was sexual gratification or arousal.
Understood. And are there any affirmative defenses for indecency with a child?
Again, very narrow ones. There's a general age gap defense. The actor wasn't more than 3 years older than the child. They were of the opposite sex. This part reflects older assumptions, but is still in the text. No force was used, and the actor wasn't already a registered sex offender. It's very restrictive. There's also a defense if the actor was legally married to the child at the time. But given Texas laws on minimum marriage age, this defense is exceptionally rare in practice and often interacts complexly with other laws.
Okay, let's move to the other specific relationship statute. Section 21.18, improper relationship between educator and student. This is clearly about policing the power imbalance.
Absolutely. This law targets employees of any public or private primary or secondary school, so teachers, coaches, administrators, staff, anyone employed by the school. The victim is defined as a person enrolled in that school or even a student participating in a school-sponsored activity, like maybe a UIL event hosted elsewhere. The prohibited acts are the same core sexual acts: sexual contact, sexual intercourse, or deviate sexual intercourse between the employee and the student. Crucially, the law assumes consent is legally impossible due to the inherent power imbalance. The student's perceived willingness is irrelevant.
And how seriously does the law view this abuse of authority?
It's classified as a second-degree felony. That high penalty reflects the profound violation of trust involved when someone in that position exploits a student.
This statute also has some interesting confidentiality rules. It seems to try and balance protecting the student with maybe due process for the accused employee.
It's a tricky balancing act, yes. The law is very clear. The name of the student involved is confidential. It cannot be released to the public under open records laws. That's a strong protection for the victor's privacy. For the accused employee, their name is also generally kept confidential until they are formally indicted by a grand jury. However, there are important exceptions where the school can release the employee's name earlier. If required for mandatory reporting to the Texas Education Agency, TEA, or law enforcement, if needed to comply with local school district policies about community notification, or if necessary, to conduct a thorough internal investigation.
And defenses for the educator. Is it just the marriage defense again?
The spouse defense does apply, yes. The only other affirmative defense is very specific and time-sensitive. The educator has to prove two things. One, they were not more than 3 years older than the student, and critically, the relationship between them actually began before the person started working at any public or private K-12 school. This aims to prevent the law from penalizing pre-existing relationships that meet the age gap rule, while still strongly prohibiting relationships formed because of or during the school employment.
Right, that makes sense. Okay, we've covered physical acts, patterns, public order, kids, educators. Now for the really modern stuff, the digital age offenses. The law is clearly trying to grapple with cameras, the internet, AI, starting with invasive visual recording, section 21.15.
This is all about recording someone without permission in situations where they expect privacy. And like everything else, it hinges on super specific definitions. We need to nail down intimate area and reasonable expectation of privacy.
How does the law define intimate area for this purpose?
It's very precise. The naked or clothed genitals, pubic area, anus, buttocks, or the female breast below the top of the areola. That detail below the top of the areola is a perfect example of legal drafting, trying to create a clear, measurable line for courts to follow. No ambiguity about where coverage ends and exposure begins for the purpose of this law.
Okay, and what counts as a place in which a person has a reasonable expectation of privacy?
The law defines it generally as any place where someone would reasonably believe they could get undressed or be private without being secretly photographed or filmed. It specifically lists examples like a bathroom, a bedroom, or a changing room. So the offense happens if someone records, broadcasts, or transmits a picture of an intimate area when privacy is expected, or if they record anyone in a bathroom or changing room where privacy is expected. And they do it without the person's consent and with the intent to invade that person's privacy. You need both the lack of consent and that specific invasive intent.
And crucially, just putting up a sign saying area under surveillance doesn't automatically get you off the hook, right?
Absolutely critical point in subsection E. The law explicitly states that a general sign warning about recording is not sufficient by itself to prove the person consented to being recorded, especially concerning their intimate areas or in a private space like a changing room. This prevents businesses, for instance, from claiming a blanket consent to film inappropriately just because they have a generic surveillance notice at the entrance. This offense is a state jail felony.
Okay, next up is Section 21.16, unlawful disclosure or promotion of intimate visual material. This is what most people call revenge porn.
Right, and it's a complex offense with several elements that all have to be proven. Let's break them down. 1. The actor discloses intimate visual material, photos, videos, digital images, without the consent of the person depicted. 2. The actor does this with the intent to harm the person depicted. Malice is key. 3. The actor knew or should have known the material was obtained or created under circumstances where the depicted person expected it to remain private. 4. The disclosure actually causes harm, emotional distress, financial loss, etc., to the depicted person. And 5. The disclosure somehow reveals the identity of the depicted person through the image itself or accompanying text. All 5 must be present.
And it's not just disclosing, but also threatening to disclose.
Correct. Subsection C makes it a separate offense to threaten to disclose intimate material in order to get some benefit, money, sex, property, whatever. Promoting a website dedicated to posting this kind of material without consent is also covered.
And the law specifically protects victims who might have originally consented to the creation or private sharing of the image, right?
Yes. Subsection E is vital here. It explicitly states it is not a defense that the depicted person created the image themselves, or that they agreed to send it privately to the actor. Consent to create or consent to share privately with one trusted person is not consent for that person to then blast it publicly with intent to harm. The law protects against that betrayal of trust. This is also a state jail felony.
Okay, now for the really new stuff. Section 21.165, unlawful production or distribution of certain sexually explicit media. This is the deep fake law. This feels like the legislature really trying to get ahead of technology.
It absolutely is. This is probably the most forward-thinking and maybe the most technologically challenging section in the whole chapter. The core definition is deep fake media. It means visual media photos or videos that's been created or significantly altered using software, machine learning, or AI. And the key test is that it appears indistinguishable from an authentic visual depiction of a real person, but shows them doing something sexually explicit that they did not actually do in reality. That's standard, indistinguishable. That's a huge technological bar and one that's constantly moving as AI gets better.
And the crime is creating or sharing these fake, explicit images without consent.
Yes. Knowingly producing or distributing deepfake media that depicts a real person, identified or identifiable, with computer-generated intimate parts, or engaging in sexual conduct they didn't actually perform without their effective consent.
And the consent needed here is way, way stricter than for anything else we've discussed, isn't it?
Phenomenally stricter. You can't just say, yeah, sure, or imply consent. The law demands a very specific proof. Effective consent for a deepfake must be a signed written agreement. It has to be drafted in plain language the person can understand, state they're knowingly and voluntarily agreeing, and include a general description of the sexually explicit media being created. This is practically like requiring a contract. It shows how seriously the law views the potential harm of creating synthetic, non-consensual pornography.
And like the revenge porn statute, threatening to make or share deepfakes is also illegal.
Yes. Subsection B1 covers threats. Threatening to produce or distribute deepfake media specifically to coerce, extort, harass, or intimidate someone is its own offense. It's a Class B misdemeanor, but elevates to Class A if they have a prior conviction or if the victim is under 18.
What really jumps out here are the defenses specifically written for tech companies, for AI developers. It seems the law is telling them they can't just be neutral platforms.
That's exactly the implication, and it's fascinating legally. The law basically says, we know your tools can be misused, so here's how you avoid liability. It offers an affirmative defense to two main groups. First, internet service providers, hosting services, etc., are protected if they're just acting as passive conduits, technically transmitting the data without modifying it or choosing recipients, standard stuff. But second, and this is the big one, the developers of the AI or software used to create the deepfakes get a defense only if they meet certain conditions. They have to establish terms of service prohibiting the creation of this illegal deepfake media, and they have to take affirmative technological steps to prevent it.
Affirmative technological steps.
Right.
What does that actually mean in practice for an AI company?
The law gives examples. It means things like actively training their AI models to recognize and flag non-consensual deepfake pornography, providing easy and effective ways for users to report this kind of content, implementing filters to try and block prohibited media before users see it, and even trying to filter it out of the data used to train the AI in the first place. Essentially, the legislature is saying to Silicon Valley, if you want legal protection, you need to build safety features against misuse directly into your powerful tools. You have a responsibility.
Wow. Okay, almost done with the digital section. Let's quickly hit voyeurism and the last couple of electronic offenses.
Sure. Voyeurism, Section 21.17, is simpler. It's about the act of secretly observing someone. This can be direct visual observation or using technology, like a hidden camera feeding a remote screen. The key elements are observing another person in a dwelling, like their home, where they have a reasonable expectation of privacy, and doing it with the intent to arouse or gratify sexual desire. It starts as a Class A misdemeanor, but jumps to a state jail felony if the victim is under 18 or if it happens on a college campus. And if both apply, under 18 victim plus prior conviction for same, it's a third-degree felony.
Okay, then Section 21.18, sexual coercion. This seems all about using threats to get something sexual.
Exactly. The core of this offense is making a threat to commit one of a whole list of other serious offenses. Things we've discussed like continuous sexual abuse, 21.02, invasive recording, 21.15, sexual assault, 22.011, revenge porn, 21.16, etc. And the purpose of making that threat has to be to compel the victim to provide one of three things. 1, intimate visual material of themselves. 2, an act of sexual conduct like intercourse, DSI, or contact for arousal gratification. Or 3, money or some other variable benefit. And the law specifically notes it doesn't matter how the threat is communicated, email, text, social media message, online chat, it's all covered.
And finally, the perhaps simplest digital offense, unlawful electronic transmission, Section 21.19.
Right. This targets the sending of unsolicited, explicit images, often called cyberflashing. It's a Class C misdemeanor, which is the lowest level offense, usually just a fine. You commit it if you knowingly electronically transmit visual material that depicts sexual conduct or exposed intimate parts. And the law specifically includes covered but identifiably turgid male genitals here to someone who did not request it or expressly consent to receive it. It's basically the legal response to unwanted dick pics.
Got it. Okay, that was a lot. We've covered an incredible amount of ground today. We went from those very clinical, precise legal definitions of physical acts all the way through to these really complex laws dealing with ongoing abuse, professional duties, and the absolute minefield of digital technology, AI, and online harm.
It really shows the scope, doesn't it? And I think the key takeaway for you listening is that this immense detail isn't just lawmakers being pedantic. Chapter 21 is like a living map of society's attempt to draw lines around harmful behavior, lines that have to constantly be redrawn as behavior, and especially technology, changes. That specificity about intent, mental states, timing, locations, even down to parts of anatomy, it's all necessary to build laws that can actually work in court, that are clear enough to prosecute, but also fair enough to withstand challenges.
Yeah, the evolution is constant. Which brings us to our final thought for you to chew on today. We saw how incredibly specific the definitions can be, like for sexual contact. And we saw these brand new, highly technical laws trying to address deep fakes and invasive recording. So the question is, given how fast technology, especially AI and digital imaging, is evolving, how often will lawmakers have to go back and rewrite parts of this chapter? Can the traditional, relatively slow process of legislation ever truly keep pace with the speed of technological change when it comes to preventing new forms of digital harm and manipulation? Is the law always destined to be playing catch-up?
That tension, that gap between the speed of tech and the pace of law is really the central challenge for legislators in this area, isn't it? But hopefully this deep dive shows why understanding the actual words of the law, the statutory language itself, is the best way to really get informed about the rules governing some of the most sensitive parts of human interaction. Thanks for digging into this with us today.
Absolutely. We appreciate you joining us. We'll catch you next time for another deep dive.